Greetings, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Fernanda Suriani, and this is the fourth panel of the fourth day of the event. Before starting the panel, in name of the ICAIL organization, I'd like to thank our platinum sponsors, JUS Brazil and Albert Einstein Israeli Hospital, our gold sponsors, Logarithm, Legal Code, and PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Opsi Bloom Lawyers, and Oasis Open. Now, I would like to introduce Mr. Andrew Vold, who will present the paper with the title, Using Transformers to Improve Answer Retrieval for Legal Questions. The stage is yours, Andrew. Welcome.
Great, thank you. So hello, my name is Andrew Vold, and on behalf of Thomson Reuters Labs, I'll be presenting the work that I did with Jack Conrad using transformers to improve answer retrieval for legal questions. Okay, so consider that you're working at a legal tech startup company named Litimate, a friend for legal research, which is a fictional company. So you want to create a question answering system because you've been receiving complaints from your users that search doesn't satisfy their natural language queries. Well, you have access to a large legal database and you have user query logs. In addition to all that, you have a team of subject matter experts. Is that going to be enough? We'll see. So some of the strategies you could use for question answering is answer snippet identification. This is similar to the squad problem. And the pro is that you're able to produce concise answers from any length documents. But the cons are that legal documents are often really long, inference over long passages can be really slow, or they might not fit into your transformer window. And then in addition to saying whether or not the passage is a sufficient answer, you need to identify the boundaries of the snippet. So another strategy that can be employed is answer generation. The nice thing about generation is you're able to produce unique answers to any kind of question, but the answers often look really nice to the untrained eye. However, it's really difficult to control the generated text, and the answers are not legally sound, which is not, ideal for the legal company. And the structure of legal text is not trivial, and there's potential for harmful bias. The final task you could do would be question answer classification. Some of the pros is that passage classification is a lot easier to implement than snippet identification or generation. The answers are legally sound because you have subject matter experts curating the data, and there are a larger variety of model architectures that you can use for the task. Some of the cons, though, are that you need to have some extensive pre-processing and cleaning in order to have a robust system. And then content might not exist for a particular query that your user is asking. So we'll take on the question answer classification strategy. So some of the ways we can do this, one, we could use classical machine learning, where we use like a bag of words approach, or we could use embedded features like your glove embeddings. Classical machine learning models are usually faster and smaller than transformers, which makes them easier for a production system. However, because of their small size, they're less capable of interpreting legal concepts. Pre-trained transformers, however, are able to utilize the power of transfer learning to learn the English language or whatever language you're working in ahead of time. And then when you can do fine-tuning on your specific legal data in order to gain more of a grasp on the legal concepts. Transformers, however, are usually larger models, which makes them better equipped to interpret legal language. However, because of that, they're slower and they're more prone to overfitting. So let's talk about how we would build this pipeline. So the plan of attack first, we need to talk about how we would pre-process and clean the content, how we would actually do the fine-tuning of a pre-trained transformer, how we can use a lexical semantic overlap mechanism to have a more fine pool of candidates, and then performing the actual inferencing on the retrieved candidates. So content handling, oftentimes legal content has this hierarchical structure where you have a document, and then within each document, you have several sections, and within each section, you have several headings. And then finally, within each heading, you have several paragraphs. So it's a lot easier to take on individual paragraphs than taking on the entire document. And so also legal text can be noisy and contain superfluous information for a transformer model. So as a result of that, you can use some techniques like regular expressions, rule-based filtering, etc., in order to have something that's easier for a transformer model to understand. So if you look at the example to the right, this is just a toy example I made up. Sentences that contain for more information, ... usually are not content bearing for a transformer. If there's a sentence that doesn't actually contain English words or parentheses, we want to get rid of that for feeding it to the model. However, it's important that the answer presented to the user is up above, because a lawyer, a legal professional, is interested in the citations and the additional information. So doing this iterative model training cycle, we have our user log of queries, and we can take our initial classifier and run some predictions. And so with these predictions, we have some candidates, some QA pairs, and we can use our subject matter experts to assign grades to those. And once we have those graded QA pairs, we can train our model, our transformer. As you can see, our transformer here is working real hard. And we iteratively repeat this process until we have a model that we are satisfied with.
5 more minutes, Andrew.
So now the application pipeline. So what that would look like is it ingests user queries. And oftentimes you have a lot of content. So instead of using a single machine, it's advantageous to use a cluster of machines. And because inferencing over passages can take a while with a transformer model, we don't want to run inference over all of the passages in our content. So we have to use a lexical semantic overlap technique to reduce the size to something smaller, something more relevant. And we take the top end. And n can be 100, 1,000, 10, 50. It's up to the designer of the system. And then once we have that, we can pass those to the transformer model and then give the top answers to the user. Okay, so now I'm going to talk about an illustrative question answering experiment. This experiment is not indicative of what an application pipeline would look like, but more so is to demonstrate the power classifier over traditional systems. So the data that we used was the privacy QA data, which is an open source data collection concerned with digital privacy. You can see the data set specifics here. The data is often really challenging. The user queries are often not very idiomatic, can sometimes contain misspellings. The answers often are run-on sentences, contain links, things like that that can be distracting to a model. The green answer here is the positive labeled answer, and then the red example here is the negatively labeled example. And I chose those just to kind of illustrate how difficult it can be to do this classification experiment with this data set. So we're going to consider the setup where we have a baseline, which is a linear TF-IDF or linear SVM classifier with TF-IDF input features. We'll do 5-fold cross-validation and a randomized search to find the optimal hyperparameters. Once we have that done, we can take our transformer model, use that optimal fold that was found from the previous baseline, and then train on those QA pairs with their relevancy labels, and gradually unfreeze until the transformer is sufficiently trained. So now in the comments, you can feel free to place your wagers on who do you think will win this fight. All right, here are our results. As you can see, we have our 2 distributions below. The first distribution is the Roberta scores, so the type of transformer that was used for the experiment. As you can see, there's more blue-orange separation, which is what you want to see. And the black line is the optimal decision boundary over the test data. And then for the SVM, you can see the blue and the orange are closer together, which is not quite as ideal. We achieved a 31.6% improvement in the mean reciprocal rank, which is essentially a metric between 0 and 1, 1 being your answers are always at rank 1, and 0 meaning you never get your answer. So the baseline had an MRR of 0.1, which means on average, the correct answer was at the 10th rank. And we also had a 23.4% improvement in the F1 score, both of these results being statistically significant. So to conclude, question-answer pair classification is a viable way to answer user queries. Pre-trained transformers oftentimes can outperform traditional ML techniques, and we don't really need that much fine-tuning data, and it need not be excessively clean. And then finally, with the right ingredients in place, you can implement a transformer-based QA system to satisfy your user's natural language queries instead of relying on some sort of lexical matching in search. Thank you for your time, and I'm happy to answer any questions now.
Thank you very much, Andrew. So we have some questions for you. Is there any special reason why you used a data set consisting of privacy policy questions during the experiment?
That's an excellent question. The reason for it is we wanted to choose a data set that was open, a publicly open domain, or not domain, available to anyone, so that one could reproduce the results. We didn't want to use any kind of internal data or things that we weren't able to show. And the privacy QA data, though it's not specifically just like general legal, it's close enough to the legal domain such that it can be illustrative of the types of problems you would see in that type of system, if that makes sense.
Okay. And what measures did you take to avoid bias in the selected data set that incorporates specialist answers?
To avoid bias, well, so the data was curated by a different organization. So we didn't actually have, take any specific care in bias. However, there was a little training, testing, contamination in the queries. So we did have to remove some of the queries from the test set and put them on the train set in order to have independent queries between those two sets.
Okay, perfect. Thank you very much. Now, do you want to make any final comments?
Thank you for having me. It's been a lot of fun and hope you learned something.
Thank you very much. It was quite an interesting project. Congratulations. So now I would like to introduce you, Mr. Andrew Paley. We're going to stream a previous text that he already presented, and then we'll have 10 minutes for answer some questions, okay?
So my name is Andrew Paley. Like she just said, I am a PhD candidate at Northwestern University. I work in the C3 lab, and I'm here today to talk to you about our paper, From Data to Information, Automating Data Science to Explore the US Court System. So the important thing here is, sorry, I'm having a bit of a technical thing, one moment. So to frame this, to step back and put a frame on this whole thing, the US federal court system might feel like a monolith, and it might seem like one massive unit, but in fact, it's a tapestry of countless unique decisions made by individuals across hundreds of thousands of cases filed annually, as those cases work their way through 94 district courts, 13 circuit courts, and on up to the Supreme Court. To get an understanding of what's actually happening in this court system, we have to actually be able to answer a series of questions. And those questions, and there are a lot of those questions, they include how often are fee waivers granted? Does it differ by district or case type? Do judges treat parties differently if they're self-represented, if they don't have legal representation? Do cases take longer in some districts versus others? Does that change by case type? Do judges nominated by different parties behave differently? And has any of this changed over time? And getting to the answers to these types of questions from the raw data produced by that massive system is in some part a technology problem, but it's also a problem of understanding domain. It's a problem of understanding the questions to ask. So the work we're doing and the work that we present in this paper is actually part of a broader initiative called SCALES. And SCALES is composed of about 24 individuals working across law, computer science, journalism, and social science at a host of different US institutions. And they're all working towards, we're all working collectively towards this one goal, which is to bring transparency to the systems and processes of the US courts, ensuring that they are fair, efficient, and accurate. There are different parts of this problem, and different groups within SCALES are working on different pieces of it. But the one we care about and what's covered in our paper is how we go from the data, the information created by that system to the answers to those questions I presented a moment ago. Now, when we talk about data from the US court system, we have to at least note PACER. So the PACER system, the Public Access to Court Electronic Record System, is paywalled. So this is how we get access to public records, the court records, but they cost money. It's 10 cents per page, maxed out at $3 per document. The result, in effect, is that analysis at a system level is prohibitively expensive. If you care about one case or 10 cases, getting the documents associated with that is not a big deal. You start to do system level analysis across tens of thousands, hundreds of thousands of cases, and it becomes too expensive to bear in most cases. That is not the focus of the work we do in this paper, but it is something that the broader SCALES initiative is focused on. How are we getting access to the data from all the different districts, and also tracking pending legislation that's working through Congress to address this problem. But let's say we had the data. So let's imagine a world where all that data was actually available. You know, there's a version where we can sort of high five and we go home and we're happy with the fact that we made the documents free and we put them online. And that is a reasonable end state for a lot of open data initiatives. But you know, this is sort of the put it all online, let someone else sort it out approach to information access. And I don't think it's hard to imagine that if you went to someone who cared deeply about the court system, about justice in the United States, say a legal scholar, a lawyer, a journalist, and you handed them millions of documents and they wanted to understand something about the system broadly, they might feel like that's a relatively opaque form of transparency. So this is where the work that we cover in our paper actually starts. And so the big idea here is there's two hops in our paper. There's two tracks. One hop is from documents to structured data. And that is, that's what we cover here. And the other hop is how we get from data to the answers to those questions. But documents to structured data, what are we starting from? We're starting from 270,000 case documents, case dockets, excuse me. If you're not familiar with what those look like in the US, that's really just the overview of a case. So that's the district, the name of the case, the judge or judges, the parties, the type of suit, criminal or civil, the nature of suit, if it's civil, who are the lawyers involved, if the case is finished, what was the date terminated, and what was the outcome. And in between, the docket entries trace all of the events within a case. And those are unstructured text. Those are hand entered by people. They're different across districts. They can be different based on just the clerk entering them. So how do we go from that to structured data? A database of 25 to 30 tables. Takes extraction. You have to pull those HTML documents apart. It takes enrichment. So we're deriving a bunch of additional data points. The simplest example of that is case duration, where if the case has finished, we have a date filed, we have a date terminated, and on the way in, we're deriving, the length of the case in days and storing that. There's a host of other features we're deriving like that. It includes language modeling. By the way, all of this is covered in more depth in the paper, so there's plenty of details to dig into there if you're interested. The language modeling component, as we talk about in the paper, we're using to classify docket entries. So the early experiments are related to motions. We want to be able to track, if a docket entry is a motion, and then it's a motion of what type. From here, the ongoing work is classifying other types of docket entries. So orders, one example, responses to motions, case outcomes. And so that work rolls forward. Sort of implied by that is the notion that we are ontologizing cases, right? We're trying to get to the right layer of abstraction such that we know what tags to generate, what types of features to look for, so that we can create sort of the overall map, the contour of a case for the sake of case comparison. So this work is one thread under the scales banner. Like I said, the details are included in more depth in the paper. And it's the hop from documents to structured data. Now, there's a version of the world we say, great, now we're done, right? We've done the work up front to go from these unstructured or semi-structured, this raw data, and brought it into structure. We've done the world a service, and we put that online, and people can now come and get the information out as they see fit. That step of getting the information out as they see fit, of course, takes one of two things. It takes skills or it takes resources. So skills, you want to make use of 25 to 30 tables with millions of entries. You need to know how to write code, create SQL queries, generate visualizations, possibly work with language models, etc. Or you need resources. You need to be able to hire someone that has those skills. This is like, data scientists as the human interface, or graduate students in some cases. So if you don't have skills or resources, then if you're a journalist or a legal scholar who actually wants to understand that data, to ask questions, to get the answers to the questions we looked at up top, then we get to a place where open data is actually necessary but insufficient. And this is true broadly. So we're talking about US federal court data right now, but any open data, open government initiative that stops at we've put the data online somewhere, now you go figure it out, is sort of half the battle. And what we really want is open information. And this is really what we mean when we say open data. It's sort of a proxy, but it's a halfway. So how do we bridge this gap then? How do we go from structured data to information? Well, what we're getting into then, just like the title of the paper suggests, is automating data science. And the goal for this second track of work we cover in the paper is that we want to empower non-technical users with the tool set necessary to drive data search and analysis without a data scientist in the loop. So how do we do that, right? And that's what we'll be talking about through the rest of this paper now, for this presentation. Well, if we want to automate data science, we have to understand what data scientists do. And we're sort of rolling it up to 3 high-level buckets. No offense to any data scientists in the audience. Of course, there's a lot more to it than this. But the sort of interaction pattern starts from when a domain expert enlists a data scientist to dig into data. The data scientist needs to take stock of what's available and surface the space of the possible back to that domain expert. This is the data we have on hand. This is what we can do with it. They then can listen, have conversations with the domain expert, and translate the information needs, the questions, back to queries and analytics. And then when an answer is arrived at, bring that answer back and communicate it in a way that's clear to the domain expert. So if we want to automate that, if we're trying to build a platform that fills that role, we need a system that doesn't remove the complexity of data science or data analysis. It instead puts as much of the burden as possible on the machine. So that is the Satyrn platform. That's what we're building in the C3 lab. We don't name it in the paper. We discuss it in detail, the version 1 of it. But the name we've given it is now Satyrn. So the scales application, the demo I'm about to show you in a moment, is an instance of Satyrn. And we'll dig into the particulars during the demo, but the things to take away at this level, looking at this bird's eye view, is that the user experience is what we call a natural language notebook. You might get the riff from Jupyter notebooks if you're familiar with them. We're borrowing from the paradigms of data science tools, but instead of saying the inputs are code, we're saying those modular steps, that sequential data exploration is now supported by simplified filters and plain natural language statements. The other thing to note as we go into this is that the system itself has nothing about any domain or data set hard-coded in it. The query generation, the analysis engine, the search components, the API, and the front end, nothing about a particular data set. That's brought to the system through an ORM layer and an ontology configuration. I don't have time in the presentation to go deep on this. We cover the V1 in the paper, but the long and short of it is we need that specification of the database, the ORM, the list of tables and fields, and we need a little bit of metadata on top in V1. And this is stuff that abstracts away the schema and brings it closer to the mental model of a domain expert, someone who's asking questions, right? So this is stuff as simple as, it's not 3 or 4 fields that are strings in a particular table, it's a judge's name and they have a relationship to a case. So when a user says, I want to search by judge's name, they're not thinking about the particulars of the joins and the underlying fields, they're just entering some text and the system takes care of it. This also includes stuff like, it's not just a float, it's a case duration and it's measured in days. So where we're headed in V2 is collapsing this all down into a much simpler representation that looks a lot more like a standardized ontology with entities and attributes and relationships and a hierarchy. And that part is not in the paper, that's a matter of future work, but we're really excited about where we're headed with it. So, demo. I'm gonna jump out of this and move my share over, okay. So I trust at this point you are seeing a web browser and someone shout if not. So what we're looking at now is a Satyrn notebook. It's an instance though of the Scales platform. So the data that's loaded in is the data we've been talking about, right? This is case, these are case dockets. So if I open any of these up, I can dig around in the actual data of an individual case. But we want to support that, but what we care about most is asking questions across the whole data set. So let's collapse that data view. There are 267,000 dockets loaded in there, and I'm going to add a filter. The filters are, again, derived up from that layer of data semantics on top of the database. I'm going to say district. I want to look at the Northern District of Illinois. It's where I'm from, but also it's where we have the most data currently. So I make a selection and the filter updates. So now I'm looking at, my data context has 104,000 case dockets in it. Let's ask some questions. So I'm going to add some analysis. The system asks, what do I want to know about? In the current iteration of the platform, we're presenting this as a sort of search or select dropdown, but it's, as you can see, it's not a great browsing experience. These statements are all the permutations of analysis that the system knows it can do, that it has inferred from states in the data, as well as what it knows its core analytics engine is capable of. So it's better to search than to browse. So I'll search for duration, and let's find out how long cases take in the Northern District of Illinois. So on average, they take 348 days. That's a really quick response to, search across or analysis across 104,000 cases. I can find out a little bit more if I want, a description of that metric, how it was derived, which again is pulled up from the underlying representation, and the data validation details. So the system will tell me, hey, you wanted to run analysis across 104,000 cases, but 6,000 of them actually didn't have a value that I could run an aggregation on, so I omitted them. We're still looking at an average across 95% of the data. And by the way, in terms of average case duration, that's just because the case hasn't ended yet. So we don't have a duration calculated. So now I might want to say, I want to know about that over time. How has duration changed year over year? Oh, gotta spell year right. I'll make a selection. And this time the system will respond with a line chart. And this is because it understands when I'm talking about something over time, a good way to present it is line chart. If I'm talking about a distribution, a good way to present it is bar chart and so on. So now I've answered a couple questions. I get a sense of how case duration has changed year over year in a little interactive chart. And Now I decide I want to drill in more. So I can add a second filter. This time I want to look at cases with a nature of suit related to intellectual property. So I'll select that.
Daily, just more, just 3 minutes last.
Yeah, I got 2 or 3 minutes and I'll be done. Oop. So property rights, that's what I wanted to search. So nature of suit, property rights, which I know is tied to intellectual property. And note that from that data context updating at the top, the questions below now update. So now with that additional filter, we see that cases go much faster when they're related to property rights. And interestingly, we see they sped up, right? And so from here, I might want to ask a whole bunch of follow-on questions. For the sake of time, I'm only going to ask one more. I might want to know about caseload per judge, right? And I could ask that question directly, but I could also break that caseload picture down by different dimensions. And so I will do cases per judge year over year, broken down by judge tenure. Let's see where that is. Cases per judge, group per judge tenure. Here we go. And so now I get a much sort of deeper portrait of the analysis. And I see that actually right about when those cases were speeding up, as I can see from this particular chart, that's when a whole bunch of brand new judges who had been on the bench less than 5 years, started to actually get those cases. So I can't go much further, but what I hope this is giving you is a sense that I'm able to explore the data very flexibly, apply filters and ask a whole bunch of different questions in this notebook format without knowing code, without knowing SQL. And so just to wrap up, early results are looking promising. I trust you can see the slides again. Early results are looking promising.
Slides. Yes, we can see the slides.
Cool. Preliminary user testing across 15 subjects. We're actually in a second round of user testing now, but the first round, we had people complete tasks within the system. They came back, they filled out a survey. We got high ratings on usability. We got a 73 sus score, which is considered good usability. We detail these results more in the paper, and 87% responded that they would use the system frequently. Future work, there's a track of work on the data that involves more language modeling, more data enrichment, and blending of additional sources for court records, including state courts, Supreme Court data, and then other sources like census data. And then future work on the platform involves expanding the analytics, refining the user experience, multi-data set exploration in one view, bringing new data sets through the UI, and a whole bunch of interesting things that flow out of that. In-platform language modeling, language model training, which we'll get into in future publications, as well as expanding the purview. So we're bringing this to political data right now. We're looking at bringing it to education-related data and alternative user experiences. And so on behalf of the team on the paper, I want to say thanks, and I want to acknowledge the National Science Foundation for supporting some of this work.
So, Andrew, thank you very much for your paper. Then we'll have some questions for you. First one, actually, before asking, I have to say something. This kind of tool that you develop, I think it's very important to improve access to justice, and not only to resolve conflicts, actually also to achieve what Richard Susskind says, like promoting people's legal health, you know, because you can empower people about their rights, not only about conflict and how to resolve it. So very good, congratulations. So let's go.
Thank you. Thanks very much.
So how does your system handle personal data, especially sensitive personal data, presenting legal documents? Is this a cause for concern?
That's a really great question. So interestingly, these records are already public, right? This is public data already. But the fact that there's a friction to access, that they're not easily sort of accessible, provides some sort of obscurity. So oddly, as I've dug into this issue, there's not a lot of sort of best practice here. And so in that broader scales group I talked about, we actually have a working group digging into this privacy issue because we know it's a real issue, and we want to honor the fact that we have a responsibility here. But finding the line between sort of public information, like public interest, versus privacy is a little murky, right? On one hand, it's obvious that there are individuals that show up in some of these court records. I'm trying to come up with, let's say Donald Trump shows up in a case. We wouldn't want to de-identify him because there's a public interest in his involvement in a case. That being said, on the other end of the spectrum, there's obviously a whole number of private individuals involved in certain cases that we absolutely feel the need to de-identify. And we're working on finding out that gray area in between, where the line is, such that we can implement a solution there. So this is all a long way to say, in the current iteration, we have not actually implemented de-identification, but we are absolutely tracking that it's an issue, and we have to figure out what level we want to go to, and that's part of the broader scales work.
Okay, good. The second one, what are the biggest challenges involved in transforming raw data extracted from documents into machine-readable content?
So yeah, structuring that documents to data hop, there's a number of things there. Court records are human-generated data. So, court clerks are putting that stuff in, and they're not thinking about, the system is not designed for analysis at scale. It's designed for, I'm just going to sit down and write out, what was just said, what the judge decided, times a million. So the dockets themselves, there are lots of filing errors. There are things to sort of deal with at a document structure level. And then when we get into the actual docket entries, there's an enormous amount of variance that the same thing in two different districts will be expressed different ways. And so again, there's this working group, there's an ontology sort of working group that is really just trying to come to the right sorts of abstractions so that when we come up with an ontology of motions, it covers cases as they happen, in Georgia and Washington State, that we sort of have the right abstraction level to capture everything. So yeah, I think it's dealing with human scale data, and that is from the docket itself all the way down to individual docket entries, and it's coming to the right sorts of abstractions across all of the things that can happen in the proceedings of a given case.
Okay, another question. Does your model include prediction of decisions?
So yeah, predictive, sort of like judicial predictive analytics. At this point, no, and we've actually decided to sort of circumvent that, at least for the time being, because we're much more interested at this stage in surfacing what's happening, right? I mean, it's more of at this stage more of a journalistic pursuit. Understanding what's going on in this massive system is the primary focus, and less so on trying to game the system, trying to figure out a prediction for a given case, because that invites attempts to game the system, and so we're not starting there, and I think in this particular project we will not head there.
Okay, thank you very much, Mr. Andrew Paley. Do you have any final comments?
No, other than just thanks a lot for having us. I'm really excited to be here at the conference, and I appreciate you saying that at the beginning about the nature of the work. We're really excited about this. I think we think it's important work, and we have a lot to do ahead of us. There's a lot coming, but I really appreciate the venue, the opportunity to speak.
Thank you very much. So now I'm gonna present you Mr. Devin McConnell, and we're gonna watch also his speech, and then we have some time for questions. Thank you.
And this is the case level prediction of motion outcomes in civil litigation. So some background information. Lawyers regularly predict what courts will do and what to argue. when to settle, when to sue or prosecute, and when to reduce client liability risk. However, these predictions tend to be overconfident, not well calibrated, vulnerable to some bias, and advocating for a particular view. Therefore, recently, machine learning has been on the rise to aid in these predictions. In some scenarios, machine learning methods have been predicting judicial decisions with an accuracy that exceeds legal scholars. So using machine learning also has the potential for reducing litigation disadvantages faced by the poor, racial minorities, and other vulnerable groups due to court outcomes varying with the attorney quality and client resources. So one example of machine learning being used in legal predictions is the development of a random forest classifier on US Supreme Court data depicted here on 240,000 justice votes and 28,000 case outcomes. In 2004, machine learning was actually able to predict justice votes with a greater accuracy than legal experts, which is seen on the left of this slide. And then on the right, we're seeing machine learning being able to predict individual court outcomes with a greater accuracy than legal experts, split up by the category of that outcome. So the previously discussed methods focused on court opinions, which ignored many important formal procedures that lead to a final judgment and use features that are not available during litigation. In this work, we present machine learning methods that predict court outcomes at the level of individual motions. The goal of these methods is to provide client and lawyer support tools. We hope to reduce litigation disadvantages faced by vulnerable groups due to variability in the attorney quality and client resources. So here we are focusing on predicting whether a motion to strike is going to be granted or denied. And here I'm going to be showing the complaint document of a motion to strike in New Haven, Connecticut. And a motion to strike has a significant influence on a case's outcome and therefore is an important factor in legal decision making. In Connecticut, a motion to strike is a written petition for a defendant to a judge to remove part or all of a plaintiff's complaint allegation based on a legal insufficiency. So here we are providing an overview of the pipeline that we used for our work. And we computed two sets of features from the state of Connecticut's judicial branch court administrative database, which we're going to refer to as the minimal and subset features throughout the rest of this presentation. So this database contains administrative and procedural data for all civil court cases in Connecticut. These features were also combined with natural language features from complaint documents, and we then used a grid search to fine-tune the hyperparameters of the 6 machine learning models that we used. So starting off with the data collection of our pipeline, we used information from the court database that we had from Connecticut and the complaint documents we gathered as well. So starting off with the documents, many court documents are filed over the course of legal proceedings that are relevant to motion outcomes. We focused on complaint documents because they contain the facts alleged and legal claims that are asserted. They are available to all parties when a lawsuit begins and can therefore be used to support any decision making. For these complaint documents, we needed to convert them to text-based files so that we can use them during neural embedding feature extractions. So in the PDFs, if they contained images, we had to use Tesseract, which is an optical character recognition software maintained by Google. And we use this to convert images to text with higher accuracy. And when it only contained text, we used PDF to text, which could convert the text in the PDF to just a text file for us. And then we had the input from the court administrative database itself from the state of Connecticut judicial branch. These features are useful for the prediction of motion outcomes. And here I'm showing just a handful of the ones that we found useful. So case reference number and motion ID on this slide are ones that helped us map the cases to complaint documents, while case location is a one-hot encoded feature. Case major code here, we only use vehicular cases and tort cases. Motion result codes, we only used ones that were granted or denied, so GR or DN. And then motion filing party, we only use D for denied. And then motion juris number is just the attorney juris number for a given attorney. This feature also helped us create the attorney specialization feature, which will be described shortly. We ended up extracting 7,904 motion to strikes from the database. So all in all, we defined two feature sets from the database. So the first we defined as minimal, which contained the motion juris number and the attorney specialization. And then we also defined the subset feature, which contained case location, case major code, motion juris number, and the attorney specialization. It's also important to note that this data was pretty well balanced, with 54% of the motions being granted, 46 being denied, 47 being vehicular, and 53% of those cases being torts as well. And then moving on to the feature engineering, and we'll start off by talking about the attorney specialization. Attorney specialization is derived from the case distribution of major codes for each individual attorney juris number. Again, we are only looking at the torts and vehicular cases from the database. So here we use Shannon's entropy, whose probability vector is the relative frequency of major case codes. In this figure, we sorted the juris number on the x-axis by the entropy, and we see many lawyers have a high specialization, which means they have a lower entropy. But many of these cases are because we don't have much data for some of those attorneys. But to combat this problem, we worked on something to smooth the entropy with the Dirichlet multinomial, which is depicted on the right, which means we noticed that actually we don't have as many attorneys that are specialized as we originally thought. So the difference between using regular entropy and the smooth entropy can be viewed here on the left. So in this image, it shows many people being specialized, but it's because we don't have that much data to make a formal decision on whether they are specialized or not. So this could be because they only tried one or two cases in a specific area. But on the right, there's a Dirichlet multinomial smoothing out the entropy, which is controlling the variance of the entropy for the attorneys with small caseloads. We also built features based on the complaint documents. So rule-based features will map a condition to a class, where a condition is a group of Booleans for words in documents, and the class is a motion granted or denied. An example of this is if we have a complaint document, we can call it 1109, that contains car accident and negligence. And all of these words are also considered to be in the class denied. It would map to a label true, which means that this document is going to be a denied document. So we then took these rules that are learned by this classification during the rule learners to aid in our classification tasks later. So in this work, we also developed two versions of the rule-based learner algorithms, one of which is called the simple rule learner, and the other is called the first order inductive learner. So the simple rule learner algorithm is a greedy algorithm that adds a rule with it when it increases the accuracy of the model. So it counts up the frequency of the words in a granted document, which is going to be denoted here as a green box, and counts the number of the times that word appears in all the documents. And it also, we use a grid search to determine the threshold of when to pick a word to be either granted or denied. So in this example, as mentioned, we use green squares to denote a granted document, red squares to denote a denied document, and green highlighted words to denote whether the search term was a granted word. This means the word is a rule that maps documents to a granted motion outcome. So here, the simple equation is going to be the number of granted words plus 1 over the number of words appeared in all the documents for that term, plus k, where k is the number of classes you have. So here, our k value is actually 2, so our result for this is 4/6. So the other model is the first order inductive learner, which tries to balance information gain with the documents covered. Here we're keeping track of the number of complaint documents that are granted and the ones that are denied for a given rule. But we also need to keep track of the ones that are turned denied when they are originally granted and the ones that are turned granted when they are originally denied. So here we're denoting the granted documents as green documents, so green squares that only contain the green words, and red squares that only contain the red words for denied. And we can denote the documents that become denied documents as green squares with only red words. And the same goes for the denied documents becoming approved documents. So this means a green highlighted word is a rule that maps documents to a granted motion outcome. And in contrast to rule-based features, neural embeddings attempt to represent a higher dimensional document with a lower dimensional numerical embedding. So word2vec is a 2-layer neural network that takes a text corpus in as input and outputs vector representations of the words while trying to maximize the log probability of some word for some input word. While doc2vec is very similar to word2vec, instead of using just the one input word, you're taking a vector representation of that document to condition on. We also investigated a model called law2vec, which is a corpus-specific model of word2vec, and it used 123,066 documents that were on the United Kingdom legislative documents, European legislative documents, and several thousand English legislative documents. And to continue to make richer representation of the legal documents that we worked on, we investigated term frequency inverse document frequency, also known as TF-IDF. So you would do the term frequency multiplied by the inverse document frequency, where term frequency is the number of times the term you are looking for appears in a document over the number of words in the document. So here, the number of times the term appears in a document is going to be highlighted as pink, so 27 over the total number of words in that document is going to be 400. And you're multiplying it by that inverse document frequency, which is going to be the log of the number of documents in your corpus, which is 5 over the number of times that the word is contained in a document in your corpus, which is 2. So it's important to note that TF-IDF has shown success in natural language processing and aiding in increasing the accuracy of classifiers. And in recent years, TF-IDF has shown usefulness in corpus-specific weighting. And specifically with this, we'd see a weight of 0.027, which this weight would actually be useful to increase the accuracy score of our classifier, especially when we use it as a weight on a word2vec model. And it's important to note that a higher TF-IDF weight would represent a term that is in smaller amounts of documents, but more times, and a TF-IDF weight that is smaller is in more documents, less times. And then all three of these methods that extract information from Word documents are useful as standalone ways to improve your classifiers, but we can do better. So we can combine all three of these methods to make one method to increase the classifier accuracy. And we can do this by taking the TF-IDF weight and multiplying it onto our word-to-vec model, embeddings that we extracted, and only using the rules that we extracted from the rule learner algorithm. So first we would do identifying the important rules from a rule learner, which for us, we identified that the FOIL algorithm was better off than the simple. And then we would only extract the word-to-vec embeddings from the FOIL list that was generated, and also only the TF-IDF weights from that FOIL list as well. We would multiply the TF-IDF weight that corresponds to negligence onto the negligence vector from word-to-vec, and then average out that vector for all of those word-to-vec so that we would have one averaged out vector to create a document representation of our complaint documents. So now we'll talk about the parameter optimization and machine learning models that we worked with.
Devin McConnell, just 5 more minutes, please.
Okay. So we trained 6 models: AdaBoost, gradient boosting, extra gradient boosting, support vector machines, decision trees, and random forest. So a tree classifier aims to construct a hierarchy of decision rules that recursively splits the data until a leaf is reached that denotes the inferred class label, which is seen on the left. And then boosting is a general ML technique based on building an accurate learner from an ensemble of weak learners. This is similar to using an ensemble of tree classifiers with low depth. And then we also use support vectors seen on the right that tries to classify the data through solving a convex optimization problem, yielding a hyperplane that optimally separates 2 classes. We then optimize the parameters through a grid search using a 70-30 testing and training and testing split with a 10 cross-fold validation. And then to quantify variability in these fine-tuned models, we did 100 bootstraps. So to then figure out what version of the features we wanted to use versus minimal and subset, we wanted to quantify their difference. So here, just a refresher of minimal and subset. Minimal only had the attorney specialization and motion juris number, and subset contained motion juris number, attorney specialization, case location, and the major case code. And on the y-axis here, it's the motion classification accuracy, which is going to be the proportion of correct predictions to all predictions. And on the x-axis, it's our models, which again are the AdaBoost, decision tree, gradient boosting, random forest, support vector, and extra gradient boosting. So here we did notice that adding and using the subset features with case location major code increased our accuracy overall. And we had the best performing with decision trees. So the median and mean accuracy on this model was 0.583. So we ended up only using the subset features for the rest of our results. And then we also investigated our 3 models across all different methods and compared it to a baseline classifier, which the baseline classifier had an accuracy score of 0.501. And just looking at the database features, we've noticed that the database features did score better than this baseline, but less than 0.6. And every time we added doc2vec and word2vec onto these database features, we did see an increase in accuracy score, but our best performing model was the one that had the FOIL, word2vec, and TF-IDF added on to the database features. And just so you know, as I mentioned before, the FOIL, word2vec, TF-IDF is the model that we averaged the word2vec weighted by TF-IDF from only the words that were learned by the rule algorithm. So this model gave us a 0.644 accuracy from our grid search and a mean of 0.605 from the AdaBoost model. And our decision tree had the best mean of 0.606. And we also tested the difference between predicting torts and vehicular cases for the database combined with FOIL, word2vec, TF-IDF. and noticed that SVMs were an outlier in being able to successfully predict the vehicular cases with considerable accuracy. Last piece of results here, we also calculated the feature importance from the decision trees, which feature importance is useful to let us know how the model's features contribute to predicting what we're trying to guess here. And here we're showing on the vertical axes the grouping of features from the TF-IDF, whether it be TF-IDF simple or the subsets. And then on the x-axis, it's the non-zero for at least one of those configurations. The last column is the sum of the word-to-vec features. And then we did note that major case code, attorney specialization, and word-to-vec have the highest average importances across the board. So then quickly to conclude, we did develop a pipeline that includes feature engineering rooted in legal domain. We also developed and benchmarked the first machine learning method to predict motion outcomes, also demonstrated that motion to strike outcomes are predictable with high accuracy when you use features for attorney specialization and with natural language processing. We believe that this can be useful to predict the survival rate of motion to strike with a complaint document, and believe that it can help parties to make more informed settlement decisions, as well as help rewrite complaint documents for better outcomes. And then our future work, we think better investigation in corpus-specific neural embeddings like transformer models such as BioBERT, LawBERT have seen great success, so that could be helpful. We also aim to expand this work to other motions like motions to summary judgment. Also hope to create a web interface for easier access and interaction to our models and for attorneys and clients. And then we hope to collect more data from surrounding jurisdictions and states. And we also aim to compare the results to a legal expert panel for our future work. And then just a quick thank you to the state of Connecticut Judicial Branch for providing us with our data, and my lab for the great support they've had over this past few weeks preparing, and my co-authors for the legal knowledge they provided and help with all the code. And if anybody is interested in this work, all the code is available at my lab's GitHub at Aguiar Lab Motion Predict. It has all of our rule learner, TF-IDF, word embeddings code to extract and combine the work, along with our grid searches, bootstrapping methods, and parameters for the models, as well as the models.
So thank you, Mr. Devin McDonnell. We have some questions for you. So first, Marcelo Lopez asked, is your system applicable to all courts in the United States, or could differences between procedures affect the efficiency of the system?
Yeah, so at this time, we do believe that as long as there is a court that produces some sort of case similar to a motion to strike that is like the ones in the state of Connecticut, we think that it should hold up and be comparable and have the same efficiency. We do hope to have and obtain other data from surrounding judicial courts to be able to test this.
You are muted. Sorry, we can listen.
Can you hear me? Okay, sorry. So as long as this is the scenario, it should be fine, and you should be able to do a similar efficiency to what we were getting. We do hope to get other data from surrounding judicial court systems to prove this, and work with legal scholars to help with this issue as well.
Okay, the next one is from Ruta Liepina. Are you planning to further distinguish fact and legal basis in the background sections?
So at this time, we haven't, but I think in future work, this might be a great thing to look into and further explain. This would definitely come in helpful with when we're working with other motions, such as the motions to summary judgment, and just further distinguishing the differences and working with that legal panel that we hope to as well.
Okay, thank you. And the last one from Jack Conrad. To what would you attribute the finding that there didn't appear to be major differences between the overall performance of the different algorithms?
So we did notice increased performance between the different algorithms when we added the word2vec features and the doc2vec features, but performance between the single database features was the only time we didn't really see the increased performance on some scenarios. And looking at the law2vec features, and we didn't explore this too much, but we did see some variability when we looked at the SVM could support a higher accuracy, precision and recall score than our accuracy score. So there was a little bit, but not too much. But to answer the question, we didn't look too far into the attribution to why across the algorithms this was happening, but we did notice that adding these neural embeddings did improve the accuracy score for our algorithms that we looked at. So the neural embeddings from the complaint documents did help our algorithms.
Okay, thank you very much, Mr. David McConnell. Do you have any final considerations?
I just would like to say thank you to this conference. And if anybody would like to check out our work, it's at our lab's GitHub, aguiarlab/motionpredict. So thank you so much.
Thank you very much. So now we will have a break for 1 hour and 15 minutes, and we come back at 6:30 GMT time, okay? Who want to meet other participants and exchange experience can access the Gather Town platform for a networking moment. The link is at the OpenFi platform. Thank you very much. See you soon.